Hello, my name is Emma Snape, Special Event and Program Manager for the Maltz Museum of Jewish Heritage. On behalf of everyone at the museum, welcome to our virtual program, I Dissent, Discussion on Employment Practices. This program is inspired by our newest special exhibition, Notorious RBG, The Life and Times of Ruth Bader Ginsburg, presented locally by PNC Bank. I'd like to thank PNC and all of our sponsors and partners, including today's programming partner, the Cleveland Metropolitan Bar Association, who helped make it possible to bring a first-of-its-kind exhibition like this one to Cleveland. The Notorious RBG exhibition is open now, and we're welcoming visitors to join us safely in person, Wednesday through Sunday from 10 a.m. to 5 p.m. We're using best practice protocols such as contactless time ticketing, wearing masks, and maintaining social distancing to ensure a safe visiting experience. And of course, we also welcome you to explore Notorious RBG from the comfort of home. On the first and third Tuesday of the month at 2 p.m., we offer a virtual online tour of the exhibit, or you can bring a group for a private online experience. Whichever way you prefer, you can learn more about ways to visit through our website, www.maltzmuseum.org. As a brief bit of housekeeping, if you registered through the Cleveland Metropolitan Bar Association for continuing legal education credit for today's program, please be sure to view the program on your phone or computer, rather than calling in with your phone and listening to audio only, and to complete the brief survey I will send you after the program. Thank you all for joining us today for the second program in our I Dissent series, in which women in Cleveland's legal community discuss some of RBG's most notorious dissents. Today, Kerin Kaminsky, Rose Fini, and Roni Sokol join us to discuss some of the late Justice Ginsburg's dissents related to employment practices. Kerin Lynn Kaminsky is a litigator and one of the managing members of the women-owned law firm, Giffen and Kaminsky. She is a former president of the Cleveland Metropolitan Bar Association. During her career, she has worked hard to make the RBG quote, "Women belong in all of the places where decisions are being made," a reality. In 2013, Roni Sokol founded the Sokol Law Firm, LLC, in Beechwood, Ohio. An experienced civil litigator, Roni has practiced law for 25 years in California and more recently in Ohio. Prior to opening her practice, Roni spent nearly 2 decades defending large insurance companies in high-stakes litigation, and also worked in an in-house capacity in the serious bodily injury unit of a large nationally recognized insurance company. Currently, she serves on the board of directors of the Cleveland Metropolitan Bar Foundation. And Rose Fini is the Chief Legal and Ethics Officer of the Cleveland Metroparks, where she leads a talented team at the National Award-winning Park District, which includes over 24,000 acres within 18 reservations, 8 golf courses, and the Cleveland Metropark Zoo. She is currently the Cleveland Metropolitan Bar Association president-elect and will become its next president this July. And now, without any further ado, please welcome me in joining these 3 women to the stage.
Hello, everyone. I think all 3 of us are so excited to be here today. And I hope you notice we are appropriately dressed to pay homage to our heroine, RBG. Every time I wear this blouse, people say it's my RBG blouse, so I wore it again today. So why don't we get started and jump right in? We have a very good discussion prepared for you today. And if we can have the PowerPoint pulled up. Excellent, thank you. And if we go to the next slide, we've shared with you each of our favorite quotes from RBG. And Kerin, I think that was part of your bio as well, but start folks off with your quote.
First, I got to remember to unmute each time. So yeah, my favorite quote from her is that women belong in all the places where decisions are being made.
And Roni, share with us yours. RBG has so many words of wisdom, and these are just a sampling of so many of the ones that are out there.
The quote I picked was, people ask me sometimes, when will there be enough women on the court? And my answer is, when there are 9.
And my favorite one is, fight for the things you care about in a way that will lead others to join you. So, and boy, did she embody that quote so powerfully. So we're excited to jump in. And if we go to the next slide, we're going to start our discussion with Ledbetter versus Goodyear Tire and Rubber Company. But in order to have an appreciation for what happened in that case, we wanted you to learn and know who Lily Ledbetter is just a little bit more in depth. And so we can go ahead and start the video.
I grew up in one of the poorest counties of Alabama during a time when we had very little. This is possum trot leading off right here, but my mother felt that I should learn the work ethic as a child. She had worked all her life. I had to chop cotton in the spring for my grandfather, and then you'd have to drag that cotton sack on your shoulders down the road. Picking that cotton when I was a child taught me that you give a good day's work for a good day's pay. I'm Lily Ledbetter, and I'm from Possum Trot, Alabama. I hired in with Goodyear February 5th, 1979. I wanted to be a part of the radio plant in Gadsden. We needed to work because we couldn't make it just on one salary. We couldn't pay for our home and we could not pay the mortgage. It took two people in the middle class to manage and earn enough money to sustain a family of 4 or more. I wanted more for my children than I had had, and that's why I worked so hard. There were not any women above me in management at Goodyear and Gadsden. It had only been men. Most of the women who had had those positions, they didn't last. I go into work one evening and I look in my mail and here's this note. It has 4 names and it was the 3 men and myself. We had had the same job. The lowest paid one, he had less education, less training, was younger. He was already making 600 plus more a month than I was. Goodyear paid me unfairly for 17 years, and my family needed that money. It just floored me. All the way home the next morning, I debated, do I really want to take a stand? The easy thing to do was let it go. But that's not who I am. And I told my husband, I have to file a charge in Birmingham, Alabama, and I will tell you up front, if I start, I'll be in it at least 8 years. He said, what time do you want to leave?
Lily Ledbetter.
Lily Ledbetter. Lily Ledbetter.
She worked 19 years as a supervisor at a Goodyear tire plant, but at the end of her career says she discovered she was paid far less than men doing the same job.
I started getting calls from all over the nation. This was not a Lily Ledbetter story. It was everybody's story.
Ledbetter sued, but the U.S. Supreme Court threw out her case, saying she filed her lawsuit too late.
The Supreme Court ruled that even though Ms. Ledbetter had suffered clear discrimination, the law had been broken. She had missed the time in which to raise the issue.
You can pray that it goes your way, but oftentimes it does not. We live in a country that we can do something about it.
President Obama signed his first bill into law,
Passing a law that says the 180-day time period employees have to file a claim starts ticking every time they get a paycheck.
and the woman who inspired it, a grandmother who took her case to the Supreme Court and lost, finally saw her goal realized today.
It's the story of women across this country still earning just 78 cents for every dollar men earn.
Starting with the Ledbetter bill, that was a bold step. He and Michelle, they came up sort of like I did, and he has 2 daughters, and he wants things better for them.
Equal pay is by no means just a women's issue. It's a family issue.
And he understands how hard it is on the lower class and middle class people to raise themselves up and pull themselves ahead.
The last thing they can afford is losing part of each month's paycheck to simple and plain discrimination. It's a question of who we are and whether we're truly living up to our fundamental ideals.
It was just awesome. I mean, it was just awesome. And when I walked up to the White House the morning that the bill was signed, my grandchildren looked at me like I was a rock star. I believe the president keeps his promises. When you make health care easier for women, when you make education possible for women and their families to advance themselves, women have a fair shot. We need more bills in Congress. We need paycheck fairness.
You see, an economy built to last is one where we encourage the talent and ingenuity of every person in this country.
That means women should earn equal pay for equal work.
And when we get paycheck fairness, that will carry the women's cause down the road much farther and give them more benefits. My case is over and it's gone, it's decided. But I can make a difference for my daughter, my granddaughter, and all of the young women across the nation. I believe history is important, and you should never forget where you come from. And I think the president should be re-elected for the next 4 years because then he can finish what he has started. That's why I get up every day ready to go, because there's more work needs to be done.
What a powerful story. And it just was a powerful video to give that background about who Lily was. And so let's dive into now the facts of the case. We heard an overview with respect to her story, but let's dive now into with a little bit more detail about those facts that led to the majority opinion, the important dissent, and the other actions we'll talk about. As you heard, Lily was a supervisor at Goodyear in Gadsden, Alabama from 1979 to 1998. She worked as an area manager, and initially her salary was in line with the salaries of the men performing substantially similar work. But through the years, her pay was less in comparison to the male area manager with equal or less seniority. By 1997, she was the only woman who was working as an area manager, and the pay discrepancy between Ledbetter and her 15 male counterparts was significant. Ledbetter was paid $3,727 a month, and the lowest paid male area manager was $4,286 per month, and the highest one was $5,236 per month. And as you heard Lily say, she came to learn way down the road that these pay discrepancies existed. And we'll talk about that and its impact on the case. So she weighed that decision heavily, but she decided she needed to file and challenge this pay discrepancy. And so she filed her charges of discrimination with the Equal Employment Opportunity Commission, the EEOC, in March of 1998. And then she retired in November of 98 and brought suit after she retired. Her formal administrative complaint specified that this discrimination was a violation of Title VII and that Goodyear paid her discriminatorily low salary because of her sex. So gender discrimination. At the trial court, the jury found, as you heard in the video, that it was more likely than not that, yes, Goodyear paid Ledbetter an unequal salary because of her sex. And based upon that jury's determination, the district court entered judgment for Lily for back pay and damages plus counsel fees and costs. Goodyear appealed that decision, and the 11th Circuit Court reversed the district court. And they said that Goodyear had an annual merit-based process in place that was the basis for raises to be given, and that she raised this issue too late, and that her claim was barred because she didn't file it timely enough. So then they appealed, Ms. Ledbetter appealed to the US Supreme Court, and let's jump into the majority holding of the US Supreme Court. And so if we flip the slide, thank you. Basically, we can break down this decision into two parts. The Supreme Court said that the discriminatory pay decision is a discrete act that triggers the statute of limitations. So the Supreme Court focused on when these paychecks were issued, and the two paychecks that were within 180 days of Lily filing her charges, they found that there was no evidence of discrimination in those paychecks. And therefore, her claim was not timely filed, and she was barred under Title VII to bring her claim. They also reasoned that they said that the paycheck containing a discriminatory amount of money is not a present violation, but instead it merely was the present effect of a prior act of discrimination. And so they say the current effects alone cannot breathe life into prior charged discrimination. So let's break that down a little bit into layman's terms, because we know that most of you on this call today are not attorneys, although we have 3 or 4. So what the majority opinion held is that even though Ms. Ledbetter proved in her case that she was discriminated against, there was testimony that they didn't believe. Some of the managers said that women had no role at Goodyear. There was direct testimony of gender bias and gender discrimination, and that was proved. But what the majority is saying is that discrimination happened in the past. And even though it may have led to her lower paycheck, the majority of the court did not believe the lower amount in her paycheck was a viable claim that constituted discrimination, that an act that occurred within the 180 days, and that she would be able to bring her claim timely under Title VII. Roni, Kerin, does that make sense to you? Is there any point of clarification that we should make? But basically, she was time barred because the majority of the court believed that no discrimination happened within the time frame. So Roni is now going to jump in. If we slip to the next slide, let me just see if yes, and so basically all of these words say what I just said. And now Roni is going to take us through what Justice Ginsburg says in her dissent and why the majority is so wrong.
So let's scoot down to the slide on one more. One more. There we go. Next slide. Okay, so obviously RBG disagreed with the majority. We know that. That the decision to set Lily's pay was the unlawful practice that was made many years before, and therefore her claim was time barred because the clock started ticking when they set her pay. Well, what RBG pointed out was that occurred 20 years earlier, and Lily had no way of knowing she was being discriminated against at that time. RBG noted that the unfairness of this decision and said that both the decision to set her pay where it was set and the actual payment of the discriminatory wage every 2 weeks were constituted discriminatory acts in her mind. And therefore, the claim shouldn't have been thrown out. According to RBG, every time she got a new paycheck, the 180 days started to run. And she noted that this interpretation was more faithful to the precedent and more in tune with the realities of the workplace and more respectful of Title VII's purpose. Let's go to the next slide. She talked in her dissent about that this pay discrepancy between Lily and the men she was working with was significant. It totaled over $200,000 over the time that she worked there, plus pension and other benefits. And in criticizing the majority, RBG pointed out that they didn't consider the common characteristics of a pay discrimination claim. First of all, pay discrimination usually happens in small increments. Okay, so it's harder to determine that you've been discriminated against. This is something that develops over time. Second, this pay information is often hidden from the employee. She didn't know what the other men were making until somebody pointed it out to her. And RBG also said that pay discrimination cases don't involve one discrete act. They need to be looked at differently than wrongful termination or failure to promote or refusal to hire cases, which do all involve one discrete act. Let's go to the next card. She compared pay discrimination cases more to hostile work environment cases, where the very nature of the act involves repeated conduct. She also noted that in pay disparity claims, the employer benefits substantially from these sex-based pay disparities, which makes the majority holding even more unfair. Finally, she criticized the majority, saying that allowing this case to be thrown out is totally at odds with the robust protection against workplace discrimination that Congress intended by Title VII. She closed her dissent by saying specifically that the ball was now in Congress's court and made clear that she hopes the legislature acts to correct this court's strained reading of Title VII. She let the court know in a most elegant and dignified way that she felt that their holding was closed-minded and went against the intent of Title VII.
And Roni, the point that you make, and this is probably an insight that Justice Ginsburg has in her position, talking about and she implores precedent to support her argument, her conclusion. And so it makes so much sense to equate this discrimination more to a hostile environment, like you were saying, especially because when you're not promoted, it's so readily apparent that you didn't get the promotion, right? Everybody knows about that. Or when you you don't
terminated, wrongfully terminated. It's a distinct act.
It's known, and that's why the precedent that she implores with Morgan and equating it more towards that hostile environment makes so much sense. So it's not just that she had this outcome and was just trying to say this was unfair. She put it within a legal theory that was plausible and that made sense given the distinction between the subtlety of not being paid equally and never having that information. And so to me, that just made so much sense.
Yeah, Rose, it not only makes sense because of the legal theories are more consistent, but it makes sense factually. I mean, you have to be living in some other world if you think people know that their paycheck is different than somebody else's within 180 days. And anybody that was living in the real world would have known that people don't know what other people are making. I mean, that's something that, even if it's unlawful to tell people not to talk about their salaries or what they're making on an hourly basis, that's the uncommunicated thing almost from all employers, and people don't go around talking about what they're making. So, Ms. Ledbetter had no way to know for all those years, and yet because the court really decided to put its head in a hole, if you ask me. I mean, I think she could have been much stronger in her dissent about this. She got the job done, as we're going to see, but I think she could have been a lot stronger, because both factually and legally, I think the court was strained to try to not allow this remedy.
I agree. Well said, Kerin. And one of the other things that the majority talked about is that Ms. Ledbetter should have continued to pursue her Equal Pay Act claim, which that was a part of the original complaint, but she was not successful, because under the Equal Pay Act, we don't have this same rigid statute of limitations. And but what's important to point out is that the remedies under the Equal Pay Act are far more limiting. And so that is why it is so important that this was a Title VII case, where we can look to back pay and the attorney fees and compensatory and punitive damages. But so let's move on now. Kerin, the point you're making about her dissent is something we have a couple of her quotes about, and how she came to be so, this approach came to be so important to her, and how she's given us such an impact.
Right, you want to go on to the next slide?
Yeah, unless, Emma, there are any questions, but I think.
Emma,
I think
Emma,
no, I think we're good to move on for now.
Okay.
And then if there's any questions at the end of the panel, we can circle back and I'll ask them then. Thank you.
All right, great, thanks. So, yeah, we wanted to talk just a little bit about what some of her quotes and what her thoughts were as far as when and why she would dissent. And she got more strident as time went on, as the years advanced with her dissents. She said at one point that, as you see up here on the screen, I do hope that some of my dissents will one day be the law. She definitely wrote for future decisions. She was hopeful that her dissents would slowly evolve and become the law. And there are many examples from the Supreme Court where we see that that happens. So one that is talked about the most often is Dred Scott, where the dissents ultimately became the law. It took a while, and it was incremental moving to that. And that's what she hoped. And it's one of the reasons in her dissents, she wasn't as strident in her dissent. She was always very careful. And we're going to see that in the next case we're going to talk about with Dukes, that she was very careful in her dissents. One of the other quotes that you often see from her is, and if we'll put that up, the dissenters hope that they are writing not for today, but for tomorrow. And even she said that even if her opinion wasn't going to be the law or change the law immediately, and even if it was never going to be the law, at least some kernels of her thinking or what she would point out about society, she was hopeful would be present in the future. And therefore she thought it was important to pick and choose. And I'll let the cat out of the bag now. We're going to have an opportunity to interview Justice Ginsburg here today. And she's going to talk, I think, a little bit about her philosophy about when to dissent at that time. which feeds right into that she's hoping about tomorrow. And one of the other things that you see frequently, if you put in quotes from RBG, if you Google that, one of them that comes up frequently is on the next slide, which is, "My dissenting opinions, like my briefs, are intended to persuade. And sometimes one must be forceful about saying how wrong the court's decision is." And she was extremely forceful at times. I think some of that came about not just because of time and age, but because her good buddy, Justice Scalia, was so scathing in some of his rebukes of the court that I think the tone and the tenor, if you really wanted to stress a point, I think he made it so that people felt that you had to be stronger and more strident in what you had to say. So she was definitely looking towards the future. And as Rose is going to present to us, she, with her opinion and her dissent in the Lilly Ledbetter case, she truly did help change the way and the law, because she convinced Congress to take action because they agreed with her that the court's ruling was wrong. And Rose, I'll let you pick up there.
She's muted. You're muted, Rose. Still muted.
I'm sorry about
There you
that. I'm back in the office and I've forgotten how to use my mute and unmute button. If we can have the next slide. This is just another excellent quote of the importance of her dissents. And next slide. And we'll play the video that highlights how Justice Ginsburg's dissent came to fruition.
Ladies and gentlemen, the President of the United States, accompanied by Mrs. Lilly Ledbetter.
The bill that was signed into law, it will allow people 180 days from the time they learn, basically, that they're being discriminated against, to file their charges with the EOC.
This is a wonderful day. First of all, it is fitting that the very first bill that I signed, the Lilly Ledbetter Fair Pay Restoration Act, that it is upholding one of this nation's founding principles, that we are all created equal and each deserve a chance to pursue our own version of happiness. It's also fitting that we're joined today by the woman after whom this bill is named, someone who Michelle and I have had the privilege to get to know ourselves. And it is fitting that we are joined this morning by the first woman speaker of the House of Representatives, Nancy Pelosi. It's appropriate that this is the first bill we do together. We could not have done it without her. Madam Speaker, thank you for your extraordinary work. And to all the sponsors and members of Congress and leadership who helped to make this day possible. Now, Lilly Ledbetter did not set out to be a trailblazer or a household name. She was just a good hard worker who did her job, and she did it well for nearly 2 decades before discovering that for years she was paid less than her male colleagues for doing the very same work. Over the course of her career, she lost more than $200,000 in salary and even more in pension and Social Security benefits, losses that she still feels today. Now, Lilly could have accepted her lot and moved on. She could have decided that it wasn't worth the hassle and the harassment that would inevitably come with speaking up for what she deserved. But instead, she decided that there was a principle at stake, something worth fighting for. So she set out on a journey that would take more than 10 years, take her all the way to the Supreme Court of the United States, and lead to this day and this bill, which will help others get the justice that she was denied. Because while this bill bears her name, Lily knows that this story isn't just about her. It's the story of women across this country still earning just 78 cents for every dollar men earn. Women of color even less, which means that today, in the year 2009, countless women are still losing thousands of dollars in salary, income, and retirement savings over the course of a lifetime. Now, equal pay is by no means just a women's issue. It's a family issue. It's about parents who find themselves with less money for tuition and childcare, couples who wind up with less to retire on, households where one breadwinner is paid less than she deserves. That's the difference between affording the mortgage or not, between keeping the heat on or paying the doctor bills or not. And in this economy, when so many folks are already working harder for less and struggling to get by, the last thing they can afford is losing part of each month's paycheck to simple and plain discrimination. So signing this bill today is to send a clear message that making our economy work means making sure it works for everybody, that there are no second-class citizens in our workplaces, and that it's not just unfair and illegal, it's bad for business to pay somebody less because of their gender or their age or their race or their ethnicity, religion, or disability. And that justice isn't about some abstract legal theory or footnote in a casebook. It's about how our laws affect the daily lives and the daily realities of people, their ability to make a living and care for their families and achieve their goals. Ultimately, equal pay isn't just an economic issue for millions of Americans and their families. It's a question of who we are, whether we're truly living up to our fundamental ideals, whether we'll do our part as generations before us to ensure those words put on paper some 200 years ago really mean something, to breathe new life into them with a more enlightened understanding that is appropriate for our time. That is what Lily Ledbetter challenged us to do, and today I sign this bill not just in her honor, but in the honor of those who came before. Women like my grandmother, who worked in a bank all her life, and even after she hit that glass ceiling, kept getting up and giving her best every day without complaint because she wanted something better for me and my sister. And I signed this bill for my daughters and all those who will come after us, because I want them to grow up in a nation that values their contributions, where there are no limits to their dreams, and they have opportunities their mothers and grandmothers never could have imagined. In the end, that's why Lily stayed the course. She knew it was too late for her, that this bill wouldn't undo the years of injustice she faced or restore the earnings she was denied. But this grandmother from Alabama kept on fighting because she was thinking about the next generation. It's what we've always done in America, set our sights high for ourselves, but even higher for our children and our grandchildren. And now it's up to us to continue this work. This bill is an important step, a simple fix to ensure fundamental fairness for American workers. And I want to thank this remarkable and bipartisan group of legislators who worked so hard to get it passed. And I want to thank all the advocates who are in the audience who worked so hard to get it passed. This is only the beginning. I know that we stay focused, as Lily did, and keep standing for what's right, as Lily did. We will close that pay gap, and we will make sure that our daughters have the same rights, the same chances, and the same freedoms to pursue their dreams as our sons. So thank you, Lily Ledbetter.
It's wonderful. It's wonderful. I had hoped and dreamed that this would be, because it would be so significant of our new president and his carriage of justice for people and and he understands, I believe, him and his wife both understand what it's like to be a middle-class American, and you know, most families today, it takes two people to earn a decent living. in this country, and I think they realize that, and this is one thing that will allow the women and the minorities to be paid fairly, and if they're not, then they will have an option to do something about it.
Excellent. And next slide. With that, we saw the passage of the Lilly Ledbetter Fair Pay Act of 2009. And as President Obama mentioned, it was his first bill that he signed. So always that holds a soft spot in my heart. And that's why I signed up, to do today's discussion, because I remember that moment quite vividly. And so this expands and gets at that issue that impacted Ms. Ledbetter's ability to bring her claim. And so it allows someone to bring their claim when the effect of it is still within that time period. So the fact that she was receiving her paycheck, which was a reduced amount, she would now be able to timely file her Title VII complaint and have the full remedy and effect of the Title VII. Next slide. It also amends the ADEA, the Age Discrimination in Employment Act of 1967, to also address some of the deficiencies within that context. So, so happy that, Justice Ginsburg and her dissent was able to inform and help with the legislative remedy. And now let's turn our attention towards our other case that Kerin will help us through. And Roni, I'm going to have you do the questioning because I don't have those questions when I had to make that room change.
Okay.
Okay, so is my picture up?
Yes.
Okay, all right, good, because I can't see it, so I wasn't sure. So the next case that we want to talk about is Walmart versus Dukes, in which Justice Ginsburg wrote an important dissent. And here on the screen, you can see is a picture of Betty Dukes in front of the Walmart that she worked at. And let me tell you just a little bit about Betty Dukes before. What we're going to do is interview Justice Ginsburg about the case and get her thoughts about it. But first, Betty was the lead plaintiff in the Walmart versus Dukes case. And it was a class action that was filed in 2001 and went to the Supreme Court in 2011, where the suit was ultimately dismissed by the Supreme Court. Although the case wasn't certified by the Supreme Court, Betty Dukes actually continued to work for Walmart until she retired in 2016. She had held various jobs at Walmart and was demoted and ended up being a greeter at Walmart. But she had a big heart, and from what I understand, she had a strong Christian faith. And ultimately, before the end of her life, she became an ordained Baptist minister. She was born in 1950 in Louisiana. She was one of 12 children. She never graduated from high school, but she did earn her diploma, high school diploma, and attended some college. She founded the Betty Dukes Ministry Foundation to support women workers and those who were marginalized but struggling for upward mobility. If you look at the website of her foundation, she's very proud of the fact that she lobbied successfully to remove adult books from the view and reach of children at your local grocery stores. She worked in 1994 when she started to work at Walmart. She made $5.50 an hour. And those that knew her and were interviewed said that she was always fighting for people who were themselves afraid to rock the boat. If they were afraid, she'd rock it for them. One of her close friends said that her determination was above the norm and that she was a go-getter that could do anything that she put her mind to. Those that worked with her also said that although the lawsuit didn't prevail, her efforts led to a much better working conditions and improved understanding by management of the workers' plight. Her coworkers say that her voice was most certainly heard. When she saw people in the store that appeared to be suffering, she's the type of person that would go to them, stand with them, and say a prayer for them. Her brother said that she was a woman who loved hats and took pains to make sure her hats, purse, earrings, and lipstick always matched whenever she left the house. She wanted to be ready to speak to others and to help other people. Appropriately, for a woman who loved movies, the last movie she saw before her untimely death in 2017 was Wonder Woman. So without further ado, we would like to ask Judge Ginsburg to step forward and come talk to us a little bit more about the Walmart. So Judge Ginsburg, thank you very much for coming today. We really appreciate it. And we're hopeful you can help us understand this case.
Justice Ginsburg, I was just wondering, to start our interview, who did you admire as a child? Who was your role model?
Thank you so much for that question. You know, just today I was looking through my desk and I found this picture of myself as a child. I'm going to hold it up so everybody can see it, but it doesn't look like I look today, does it? But I was thinking when I was looking at this picture, clipped to it in my desk drawer was something I wrote when I was 13 years old, and it helps answer the question about who I admired. Beyond the obvious influence of my parents, it was Eleanor Roosevelt. I wrote this when I was 13 years old about her being the chairperson of a newly established United Nations Commission on Human Rights. I wrote, based on what Eleanor had said and written, that the Charter of the United Nations had an important purpose. And here's what I wrote when I was 13. It is, whoops, I gotta get my glasses in the right place here. I wrote when I was 13, it is vital that peace be assured. For now, we have a weapon that can destroy the world. We children of public school age can do much to aid in the promotion of peace. We must try to train ourselves and those about us to live together with one another as good neighbors. For this idea is embodied in the great new charter of the United Nations. It is the only way to secure the world against future wars and maintain an everlasting peace. So from that, you can tell I was totally taken with what Eleanor was doing and was applying it to my own life and trying to help others apply it as well.
Justice Ginsburg, thank you for talking with us today. Before we go into the Walmart versus Duke's dissent, let's talk a bit more about dissent. Have your draft dissents ever impacted the majority opinion?
Well, I was listening to what Kerin said earlier in the presentation, and she's right. I tried to only dissent when it was absolutely necessary because my experience teaches that there's nothing better than an impressive dissent to lead the author of the majority opinion to refine and clarify the initial draft of a majority opinion. An illustration from my experience was the Virginia Military Institute case, decided by the court in 1996, held that VMI's denial of admission to women violated the 14th Amendment's Equal Protection Clause. I was assigned to write the court's opinion. The final draft, released to the public, was so much better than my first draft. And I probably had a dozen drafts. And that was thanks to Justice Scalia's attention-grabbing dissent. His dissent made my opinion so much better. On occasions, and actually almost 4 times a year, or term, I would estimate that a dissent would be so persuasive that it attracted the votes necessary to become the opinion of the court. I had the heady experience once of writing a dissent for myself and just one other justice. In time, that dissent I was writing for just one other became the opinion of the court, from which only 3 of my colleagues dissented.
What leads you to decide, say in Walmart versus Duke's, to write a dissenting opinion rather than just note your dissent?
That's an excellent question, because I didn't always, sometimes I just noted my dissent. I didn't always write opinions. And I tried to follow what Chief Justice Hughes famously said. He said, and I quote, "A dissent in a court of last resort is an appeal to the intelligence of the future day, when the later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed." So part of my thinking is to influence future thought. Although I appreciate the value of unanimous opinions, I decided to speak in dissent when important matters are at stake. I stress important matters because I try to follow Justice Brandeis' counsel. He cautioned that in most matters, it's more important that the applicable rule of law be settled than that it be settled right. In Dukes, I felt the theory of liability needed highlighted and hoped that my dissent would do just that.
I note that in pictures of you on the bench, you have different collars on your robes at different times. Why is that?
Well, it's really just a personal preference. I decided to wear certain collars when announcing the opinion for the court and certain collars when I authored a dissent. You know, the robes were designed for men where you could see their tie, and so you could see something about their individual nature. Whereas since women didn't generally wear ties, well, Sandra Day O'Connor and I decided to do something that would be more feminine, something that you would think of. And I wanted it to speak of what I was doing. And so in fact, Kerin here is wearing my dissent collar. And it was one of my favorites because I considered my dissents to be so very important on the future of the law. So I wanted something sparkly and something that stood out. And by the way, I got it at Banana Republic and they've reissued it recently. So you can still get one of my very favorite collars.
That's wonderful. Let's turn to Walmart versus Dukes. Can you summarize the case for us?
Sure, would love to. It was an employment discrimination lawsuit filed as a class action in federal court in 2001. It was based on the law protecting women from gender bias discrimination in the workplace. This case has been cited thousands and thousands of times in cases that follow it. So it's a very important case that has helped to shape the nature of relief given to classes of employees who claim injury by discrimination. The case alleged, based on the experience of lead plaintiff Betty Dukes and others, that Walmart made promotion decisions that favored male employees and paid women less than their male counterparts in comparable positions. The plaintiffs alleged that Walmart's corporate policy of allowing individual managers to make discretionary pay and promotion decisions created a corporate culture that discriminated against women while allowing male employees to succeed and advance. The Dukes plaintiffs didn't allege that Walmart had an express corporate policy like you would see frequently against the advancement of women. Rather, the plaintiffs complained that the local manager's discretion regarding pay and promotions was exercised disproportionately in favor of men, leading to an unlawful disparate impact on female employees. So a very novel concept that I found to be extremely valid. But the plaintiffs alleged that because Walmart was aware that its policies had an effect of disadvantaging female employees, its refusal to change those policies of allowing manager discretion amounted to a disparate impact, making Walmart liable to all the employees that were negatively affected. The case was brought as a class action, and the appeal was on the decision whether or not to certify the class identified as consisting of all women employed at any Walmart domestic retail store at any time since December 26, 1998, who have been or may have been subjected to Walmart's challenged pay and management track promotion policies and procedure. This class action, now imagine this is a class action. It was estimated that the class would have been 1.5 million people. A lot of people, one of the largest class actions, if not the largest class action ever filed.
Well, the majority found that the plaintiff had not met the standard for a class action. What was the basis of your dissent?
Well, this is an unusual case. I agreed with the outcome in this particular case. Because I believe that the way it was pled under Rule 23 of the federal rules, that it wasn't properly a class action. But I didn't believe that I thought that we needed to go back to the district court for some further holdings, and that even if it wasn't a class under 23A, it should have been a class under 23B or C. But I thought there was enough in the record that more should have been done. I concluded that there was enough evidence that plaintiffs should have had an opportunity to show that the impact of the discretion was that the company operated under a general policy that was discriminatory. One commentator I saw who was talking about my dissent said that the practice of white men promoting white men has been elevated to an art under the label of mentoring, where mentors are those in the position to bring others along. But if the mentors are all men, and those men tend to self-replicate in their selections for mentees, the collective effect of the subjective process as an organization is gender discrimination. That's perfect. That's exactly what I was trying to make sure people saw. I wasn't as worried about the Rule 23 as that people understood that the exercise of discretion could in and of itself be discriminatory. It was my opinion that the Duke's majority was simply blind to the reality of workplace exclusion. It was the court's blindness to the realities of how discretion and bias work that delivered the fatal blow to Betty Dukes and her co-workers. It was my opinion that the Duke's majority was simply blind. And I said that, as I said in my dissent, and this is what I really want to highlight for you. And I wanted to highlight by writing my dissent, is that the practice of delegating to supervisors large discretion to make personnel decisions uncontrolled by formal standards has long been known to have the potential to produce disparate effects. Managers, like all of humankind, may be prey to biases of which they are unaware. The risk of discrimination is heightened when those managers are predominantly of one sex and are steeped in a corporate culture that perpetuates gender stereotypes. I would have deferred to the findings of the district court after hearing, in which the court found indications of potential class-wide disparate impact, and allowed them to go forward and determine whether or not there was in fact a disparate treatment resulting in gender discrimination.
Did the Duke's case have the impact on claims you feared when writing the dissent?
Well, in post-Duke's litigation, the private pattern or practice class actions appeared to be dead, and with it, the advantages of pattern and practice suits for litigants in the courts. Those advantages, as you know, include the ability to address unconscious or hidden biases, efficiencies in litigation, more favorable allocations of burden and presumptions, flexibility in the remedial phrase, and broader discovery. However, despite the dire concern at the time that the opinion was issued, that the impact would completely eviscerate class claims for employment actions, the impact on such claims has been more of a, well, shall we say, a very large wave than a devastating tsunami. But it certainly has had an impact. For example, in 2010, the year before the Duke's decision, the top 10 class employment discrimination settlements totaled $346 million. In 2012, the first year after Duke's, the total plummeted 87% to a mere 45 million. Another measure of the impact is the deep drop-off in new employment discrimination class action lawsuits being filed. Before Duke's, it was normal to see 25 or 30 such cases every year. In the years that followed Duke, the number of new cases is closer to only 10 to 12 a year. So fewer plaintiffs have filed employment discrimination class actions, and those that have must incur substantial additional costs to show that the class is proper. Also, more defendants are seeking to dismiss employment cases even before the class certification determination. But on the other hand, many courts have used the parsed and unusual language used by the majority opinion, along with the suggestions in the dissent, to allow a class based on certain evidence. Subsequent courts have found reasons to find cases different from the Dukes case, and to go ahead and allow a class. I'll give you two examples of those. One is McReynolds versus Merrill Lynch, and Walmart was distinguished, and a class was permitted where a low-level managers exercised discretion, but did so pursuant to two company-wide policies that had an adverse disparate impact on African-American brokers. Another example where Dukes wasn't applied was in Scott versus Family Dollar Store, where the court clearly delineated Walmart strictures and permitted certification of a class action by indicating that the commonality was satisfied where there existed a uniform corporate policy and higher level managers were the ones making discretionary decisions that had a disparate impact on female workers, or that revealed a pattern or practice of intentional gender discrimination. It is my hope that courts will continue to look carefully at the evidence of how discretion can be uniformly used to create disparate impact. I hope that my dissent in Dukes will aid courts in thinking about this issue and the type of proof that should allow a class to continue.
Thank you, Justice Ginsburg.
Well, and thank you for having me on this very, very cold and snowy day. If I had known it was going to snow in Cleveland, I would not have come.
I don't blame you.
All right, I think we're about at the time, Rose and Roni, we might want to see if Emma, if there's been any questions or anything that we can answer.
There have been a couple questions, and I know that it's already a little bit after 5, so if we can try to keep this a little bit quick for everybody, I think that would be great. So I'm going to pick and choose from the questions that I have. So first, we got one question from the audience asking about some of the terminology used in this presentation. And some of the media that you shared, and in the way that you spoke about the cases we learned about today, the phrases gender discrimination and sex discrimination were both used. Are those terms legally interchangeable, or do they speak to two different legal concerns?
They're legally interchangeable right now. I don't know that will ever be. Perhaps courts and will catch up and understand that there's a difference between sex and gender, and I think we're moving towards that. One of the things is that a lot of the legislation we're talking about is before those terms were as well parsed as they are now. The law that we were talking about talks about sex discrimination. It does not talk about gender discrimination. I mean, that's the word it used, but it has been used interchangeably throughout.
I remember in her biography, and one of her biographies, Justice Ginsburg told a story about one of her first briefs very early on. Her secretary was typing sex discrimination over and over and over. The briefs were 40 pages long, had to be typed on a typewriter. And her secretary came out with the idea saying, maybe we should use a different word instead of sex, because that word implies, so much more. How about use the word gender? And Ruth Bader Ginsburg said, I love that. Let's change it. Go through the 40 pages and change each one to gender. And I think it changed after that. She started using that term.
I never knew that. Thank you, Roni.
It's in one of the movies, or a couple movies about her.
Fantastic. So another question that looks a little bit about the idea of gender in RBG's career is that at the time of the decision in Lilly Ledbetter's case, Ruth Bader Ginsburg was the only woman on the bench. In your opinions, do you think that a court with more women would have voted the same way?
Well, can I start that answer? I think they would have. I don't think that, I'm hopeful that life experience and how you think isn't just because of your gender. And so I don't tend to think that all women judges are gonna think alike or be alike. And I think that, you know, you were gonna have the same people appointing people. And so you were gonna have conservative judges appointed by the people who are conservative and more liberal judges appointed, or what they think of. You know, as we know, what you think a judge is going to be when they get on the Supreme Court, they can often change. Our most liberal judge, Chief Justice Warren, was appointed by a conservative because he was thought to be very conservative. So I don't think that the gender would have changed that opinion.
And the only thing I'll add is, I tend to agree with Kerin, but that sometimes we're strategic, right, about how we approach a case or how we argue it. And it reminds me of her approach with Moritz versus the Commissioner of the Internal Revenue Service. I mean, that case she took, right, was purposely of a 63-year-old male. And so she argued that case of gender discrimination that was occurring to a man strategically. So I think that your question, the question, you know, is a good one. And I think the bottom line is we need to be strategic about who the judges are. But sometimes we need to dig deeper than just looking on the face of what their gender is.
You know, and let me just, because I can, say that, you know, this isn't a political question. The answers to these questions are legal questions. They're not political questions. And so one's political views doesn't actually end up necessarily being what your legal view is. I think almost all justices would say, you know, they're using legal reasoning and they're not reasoning they're not supposed to. And most would declare that they don't reason to a conclusion that is a political conclusion. Rather, I think that we have assigned far too often in the media and in commentary now political motivations to people who are really just reading the law and trying to interpret it to the best of their abilities, albeit from different approaches.
Thank you both for those thoughtful answers. Roni, do you have anything you'd like to add, or should I move on to our last question?
Well, I was just going to say that it could have been a different result with different men on the court than, you know, so.
Right.
Answer is yes. She might have had more people join in on her dissent too.
But, you know, her dissent was ultimately what justices should do. If they're going to interpret the law and the interpretation of the law says X, and she encouraged them to change the law if you wanted a Y result. So did I get my X's and Y's right for male and female? Anyway, she did what you would hope good justices would do, which was encourage the legislature, if the legislature wants it different, to make a difference.
Absolutely. Thank you, Kerin. And so our last question tonight, before I'm going to let everybody go, in her dissent, Ruth Bader Ginsburg referred to the majority opinion as, and I quote, "the court's parsimonious reading of Title VII." This is strong wording, and it communicates the justice's sentiments clearly, but without being disrespectful or overly confrontational. How did the way Justice Ginsburg utilized language in her dissents conform with what you understand to be Supreme Court norms before this dissent? Or how did this kind of language create new norms that we might see today?
You know, just today I was reading.
Where'd she go?
Kerin? Kerin, we just lost your audio.
We can't hear you, Kerin.
And I think that I think she
Kerin,
got,
Kerin, I hate to interrupt, but we actually lost your audio, so we didn't hear anything you said until just this moment. Would you mind starting over for us so we can hear it all?
Sure. I said
Thank
that
you.
I was just reading today that she said that when she first started wearing the different collars, they were very conservative in nature. And that as time progressed, they got more progressive and much fancier and not nearly as conservative. And I think she would say of herself that she got, of course, we should have asked her when she was here, but that she got more progressive as time went on in her legal analysis. And that's because the court went further to the conservative side. And so she was trying to pull them back. So she cut, as she pulled, she went further left in some of her opinions. And so I think her language got stronger also as a result of her attempt to pull the court further left.
Actually, Emma, when I was reading the dissent, I looked up the word parsimonious. And the definition is miserly and cheap. And that's where I just kind of giggled and thought she has the most elegant way of giving it to these guys, you know, but while still being very respectful. So I think that's something very impressive about her use of language.
One thing that I remember I heard on NPR last week, actually, that I shared with the three of you over email, but was a dissent of Justice Kagan's from last week, where she came out really strongly against the majority opinion and said that this is the court comparing apples to watermelons. And that reminded me so strongly of RBG and some of the great dissents that we've been talking about in the series. So I wanted to make sure to throw that out before we said goodbye today. Rose, do you have anything you'd like to weigh in on with this last question?
No, I don't think so. I think though that I know we talked in our prep session too, you know, this isn't the first time that we saw legislative remedies come about. I think, and in fact, I think Justice Ginsburg mentions it in her dissent that in the previous, the Lawrence versus AT&T Technologies, she was critical that the court took a nearly identical approach in that instance, and it had to deal with the seniority systems in place. And so the legislator had to step in at that point too, and the Civil Rights Act of 1991. So with the Ledbetter Pay Act, it's not the first time we've seen the legislative remedies, but I think Kerin rightly points out in the dialogue that goes on, it's so important for us to preserve the integrity of our judicial system, and I think we have tried to do that as a legal profession. Justice O'Connor, from the Ohio Supreme Court, when she criticized those folks who were arguing that a judge's decision was political, Justice O'Connor, spoke out and said, no, these decisions are not political decisions. So it is so important for us to maintain the integrity of our judicial system. And when an opinion falls short, when a majority falls short, and we can see the legislators step in, that's the way our government's supposed to work.
Thank you, Rose. So now that it is about 5:15, even though I have more questions I would like to ask, I think that I have to cut myself off. So thank you so much to Kerin, to Roni, and to Rose for an energetic educational presentation. And thank you so much to the puppet of Justice Ginsburg herself for joining us today. And I would also like to thank everybody in our audience for joining us today from home. If you enjoyed today's program, which I hope you did, you can join us again next month in May for our I Dissent program, in which attorneys Kerin Rubin and Laura Hauser will be discussing some of RBG's dissents on the subject of reproductive justice. You can find more information on this program and any others that we'll be offering by visiting our website, www.maltzmuseum.org. Thank you again for joining us today, and have a wonderful evening, everybody.